I can introduce you.
Thanks, Amy.
I am really thrilled to have Alex Mooradian here today. He actually reached out to me because he wanted to get this information out to people about immigration and trauma. And I know that Worcester is a community that has a huge population of immigrants. We have some great agencies that serve this population, but there's always challenges around legal issues, right? What they can do and what they can't do. Alex and I were also talking, and I know that this audience understands that very often immigrants are scapegoats for everything going on in society. We love to sort of, and particularly our president now has often pointed to immigrants as the source of problems in our community. And that gives them a baseline of, this is a pretty scary place to start from, to be villainized and demonized like that from the sort of top office in the land. So since I've sort of heard about Alex and began communicating with him, I've been hearing from everyone in the community about what amazing work he does and what an amazing person he is. So I'm so excited to sort of have met Alex, and he's bringing a lot of new people to Trauma Training Tuesday, which is exciting. And again, we're recording this, so it will be, as soon as I have the recording done, I'll send out that link too and post it on Facebook, send it out in flyers, so that if your agency really does want to be able to use this training and this content, that will be great. That's our intention of doing these series, so that people have sort of on-demand content that's relevant to their agency. So like many other of our presenters, Alex has a PowerPoint he's going to share. And we're not entirely sure if he'll be able to monitor chat while he does his presentation. If not, I'll be watching the chat as well. So if you have questions or comments, you can put them in the chat. We'll definitely have a lot of time at the end to take questions, but if they come up sooner, that would be great. He's happy to take them if they're really relevant to something he's talking about. And I see probably, Alex, most people have their cameras turned off, which is a good thing for now, because I think that gives you more bandwidth.
Nice.
It's a rumor I heard. I don't know if it's true, but I heard that if the bandwidth of everyone on camera can pull from the overall bandwidth. So if people can use their video and audio as they need it and kind of keep it off if you're not speaking or you're not sharing, that would be fine. Although Alex might really, hi Angelique, might really enjoy seeing everybody like I do, right? Like, I know some of these folks are here for you, so you can have the joy of like seeing the familiar faces. And
right. In
the COVID world, with Zoom being all we have, it really is delightful to see you, like, oh look, there's my friends, yay.
Yeah, we'll take what we can get.
We'll take what we can get. So great, I am going to, Rose says that turning off video does help. Thank you, Rose. See, I got validation from somebody who knows IT. I didn't just make that up. But so far our bandwidth seems to be fine. Well, I am going to turn it over to our fantastic presenter, Attorney Alex Mooradian, who is going to talk to us today about trauma and immigration law.
Thank you so much, Amy. Well, I just want to thank everybody who was able to come, because this is my favorite topic, and frankly, I think friends and family are sick of hearing me talk about it, so it's nice to have a fresh audience. So I'm going to jump right into some slides, but as Amy said, make liberal use of the chat. I don't want people sitting here like, what the heck is this guy talking about? Once I wind myself up, I don't tend to stop. So definitely just jump into the conversation, and I'm really glad everybody's here, and let's do it. All right, so the trauma of immigration, I just want to give a basic summary of what we'll go over today. So I am going to talk about some immigrant stories and client interviewing. What are the needs of your clients? Why does this matter? As people who work in social services agencies or for the government or in any context where you encounter immigrants, what do you need to know, and why do you need to be involved in their immigration processes and in supporting them as a vulnerable population? We'll talk about some of the really hot issues right now, which would include protracted detention. Obviously, the Trump administration has really expanded detention. We all saw family separation issues at the border, which sometimes people think that that ended last summer. That's ongoing. And we'll talk about the trauma of not only experiencing harm or persecution in one's country of origin, but also the trauma of traveling to the United States, traveling with human traffickers, going through the immigration detention system where people are held in rooms and cages and so forth, and are interviewed by Department of Homeland Security and Border Protection officials, and the trauma of actually preparing for a trial where you have to relive and testify to your trauma history. I will talk about how COVID-19 has highlighted certain phenomena that have harmed immigrants and continue to harm immigrants. And we'll talk about public benefits, some of the action steps that agencies can take to remedy some of the serious issues that immigrants are facing, especially in the context of this current moment. So, as mentioned, COVID-19 has really cast a spotlight on so many of these issues. Immigrants do tend to face, in many cases, especially if they're undocumented, economic instability, food insecurity, housing issues, healthcare issues, mental health care issues. These are issues that face a lot of people in society, a lot of marginalized groups, but are certainly amplified if somebody does not have a lawful immigration status. And just to kind of put us in the mindset of what kind of people we're working with, I want to tell the story of a particular family that I represented a few months ago. We really have to take a step back when we work with immigrant populations, because many of us have never had the type of upbringing that this population has had, the type of distrust in government. Well, that's questionable at this point, but the type of distrust in government, the type of issues surrounding gender-based violence, gang violence, food insecurity. So it's really important to just take a step back and look at where are the clients coming from so that we can better serve them. So I'm going to read from the closing argument from this case, and I'll show some pictures. These are by photojournalist J.B. Moore, and I did get permission from the client to tell this story. So I'm just going to read it to you to put us in the mindset of this vulnerable population. The family are citizens of El Salvador. They arrived in the United States in 2015. Mother and father's daughter, M, suffers from a number of medical diagnoses and handicaps that render her unable to move her body, unable to eat on her own, unable to speak, and unable to support herself in the most basic daily functions. Despite their pleas, the family were repeatedly denied proper medical care for their daughter. Doctors in the public hospitals threatened and extorted the family, using their daughter's survival as a bargaining chip. For example, when M suffered from well-documented epilepsy, one doctor declined to continue prescription treatment after 6 years of successful treatment, and instead told the family to come pay her at a private clinic if they wanted their daughter to live. When father fled to the United States to find work to pay these medical bills, his wife and daughter were left vulnerable to the rampant gang violence in El Salvador. On 2 occasions, mother was assaulted by gang members while trying to access health care for her daughter. On one particular occasion, she carried her frail daughter's body in her arms when several armed men approached her demanding money. These 2 young women had to choose between the inadequate medical care and the threats of gang violence on the way, or having no medical care at all. Doctors and neighbors told mother that she should just bury her daughter, or that maybe they'd be lucky and the pneumonia would wipe her out, so she better get used to it. She realized that she needed to flee to the United States to save her daughter. Mother was scared, especially because she had endured several instances of sexual abuse at the hands of family members and a stranger in the past. Still a young woman herself, she nevertheless decided to carry her daughter and a son on a dangerous journey to the United States, during which her fears were realized and she was physically and sexually abused by human traffickers. Upon arriving to the United States, medical professionals were shocked by the lack of care provided in El Salvador. Those doctors inserted a G-tube because the daughter was so malnourished that her immune function had been compromised. They took basic measures to prevent constant pneumonias that the daughter had unnecessarily suffered in El Salvador. In short, they chose to put in the effort to prevent daughter from dying. Here in the United States, M has a teacher who comes to her home in stark contrast to the education she was denied in her country of origin. She smiles often now and isn't suffering from constant pneumonia. And she is receiving tertiary care in an effort to improve her quality of life, including surgeries to reduce pain, which were denied in El Salvador. The harm suffered by the family in having their daughter denied even the most foundational of medical care and bringing her so close to death is in and of itself persecution by the government-run healthcare system of El Salvador. The harm suffered by M in these medical settings and as a young child certainly rises to the level of persecution. The harm suffered by M in having her mother surrounded at gunpoint and robbed, especially from the perspective of a child, rises in and of itself to the level of persecution. The harm suffered by mother in being targeted for robbery and rape while seen carrying her daughter with quadriplegia rises to the level of persecution. The fears that the family has for the future, that M will die of medical neglect, that M will face physical attacks or sexual abuse that she will not be able to report, the gender-based violence that M and her mother could face, and the harm to the entire family of losing M to preventable death just because she is a young girl with disabilities all rise to the level of a reasonable fear of persecution. If asylum law does not protect this family, then asylum law does nothing. Accordingly, we request asylum, withholding of removal, and protection under the UN Convention Against Torture. So that was our closing argument, and I'm not going to hide the ball. We did, fortunately, win this case. But a part of the reason that I chose to talk about this case is because even though the argument position is obviously that this is a clear case and that asylum law protects this family, the harsh reality that we'll get into later is that this case was on extremely questionable legal footing. And so we have to understand that as people who are coming in contact with immigrants, we need to know the hard truths about when relief is available and when it's not. We don't want to put anybody in jeopardy by presenting information to the immigration agency and turning over biographical details that could put them at risk of actual removal from the US, especially when the consequence of that removal, we all know, could be death. So I want to talk about how do we elicit these stories. And this can be a real challenge. It requires a lot of rapport building and client communications. And I want to talk about some examples of issues that I've run into as we work to develop testimonies from clients, which are really the foundation for immigration relief. One of the issues that we see a lot are cultural norms and taboos. So for example, one client says, well, we always had enough food, of course. Each day when I was at school, I was given a meal. We really didn't eat at home. Again, we have to put ourselves in the mindset of the client because hunger is so pervasive and normalized in many countries that unfortunately kids don't recognize that as abuse or neglect. And if they can't recognize the abuse and neglect, that could be fatal to their case. Another client says, I love my parents because they give me everything I need. They just told me that I had to go to the United States for a few years to work and then I could go back. Again, a lot of clients will have
Alex, did we lose you?
Yeah.
It looks like we lost Alex. Not sure how to manage that situation.
It looks like he's still here, though.
Yeah, let's see. Are you, Jeff, you're seeing him as still here?
Yes, I am seeing him as still here. So I'm going to send him a private message and see what happened.
Okay, thank you. Thank you. It's not showing up on mine that he's still here.
Oh, he's back. I'm seeing him.
He's
He's
coming.
back.
He's back. Alex, we lost you.
Okay, we'll try to keep it going, okay? Hang in there.
Okay,
Everybody's
no,
still
that was terrifying for a minute there, but
there? Okay.
we're
Remain
good.
calm. All right. So did everybody get this slide, Amy?
I'm not seeing your slides anymore. I had your slide up, and now I just have the gallery view of everyone who's here.
Okay. Don't worry about it. We have a team on it.
We're not worried. We're not worried. It's good. Certainly, that was a really heartbreaking story. Wow.
Okay, are you with me now?
We're with you now. I see it,
Okay.
right? Got some thumbs up.
You saw this, right, Amy?
Yes. This is right where you cut off on
Okay.
that second quote you were reading.
Oh, okay. All right. So we'll pick up right here. So a lot of kids will minimize the trauma that they've experienced because they're looking at a lot of other kids doing the same thing. So one kid says the journey was hard, but lots of kids do it. That's a teenager from El Salvador, and a lot of times kids will have guilt as well. There's a certain operation of guilt where they have family who's back in the country of origin, and they don't want to say anything bad about the current country of origin, so they tend to minimize the trauma that they experience there. Mental health concerns can also be an obstacle. Some of the things I've heard: I'm too busy to see a therapist, I don't need a psychiatrist, that stuff is bad. And then family can get in the way too because of the cultural taboos around mental health. Family saying, oh, they just need rest, we'll let them have some time off from school, and so forth. The mental health concerns, there's a variety of ways to approach that, and sometimes different clients require a different approach. But I think a lot of times clients know that they need mental health care, so it can be a relief to them if you say, well, we're really just doing this for your case, or this will help support your case, you don't have to do it. If they feel like there's a practical purpose for it, I think a lot of times they're more willing to participate. But we also have to remember that mental health care can be so taboo in many countries, including the US, but in many countries it's really considered witchcraft or psychic power. So we have to keep that in mind and respect that as we approach the topic of mental health care. And mental health care obviously is essential to a claim for asylum or for protection, because oftentimes the corroboration of a psychiatrist or a psychologist who can say, yes, this person has PTSD, yes, this person has severe depression, yes, this person has anxiety, corroborates their claim that they were harmed or persecuted. Obviously, it makes perfect sense that the person who experienced this would have mental health impacts. Without that kind of statement, a claim can be questioned, certainly by an adjudicator. And then we also just have to think about the fact that a lot of kids have mixed feelings about, or a lot of kids or a lot of clients have mixed feelings about their country of origin, because yes, it may be the site of their trauma. It may be the site of persecution, physical harm, abandonment, neglect, hunger, but it can also be the site of so many of their first memories. They could still have family living there, natural beauty. So we do want to keep in mind when we're working with clients that the clients are more complex than just the trauma. And to really build rapport, we have to get into some of their positive memories, some of their joys in the country of origin, and understand that their experiences there are a lot more nuanced than what their statement is going to say or what the legal argument is going to be. And in reality, to have a nuanced statement from your client, to have a really nuanced understanding of the good and the bad, to have them say, yes, certain things did happen, but deny other things, that vulnerability actually leads to credibility. Because then the adjudicator doesn't say, well, they just threw the kitchen sink at everything and told me everything bad about their country that you can find online. They're crediting certain things, but denying others. So that's really important to understand. And then a lot of clients will have a true and earnest fear of retribution or a distrust of authority. And in many countries, the governments are so oppressive and the surveillance is so strong that clients' fears are very reasonable. Their claim itself may be due to detention or persecution on account of political opinion. So a lot of times we have to stress the confidentiality of their cases. We have to stress the confidentiality of the legal process. The Department of Homeland Security on asylum cases will not allow observers into the hearings. They will not publish the decisions on individual asylum cases. So stressing that to the client so that they understand the confidentiality can sometimes be helpful. And the part of the issue, though, is that even once you develop this case and you develop that relationship, something you do have to explain to clients, unfortunately, is that there's a certain randomness around immigration, to the extent that people think that people go before an adjudicator and they have this due process and they have this decision made based on the facts and the arguments. Unfortunately, in many cases, that's not true. There's this publication, Refugee Roulette, which is a really accurate representation, a really precise representation of just how disparate the outcomes are for immigrants, in a lot of cases based on factors like which court did they go to for their hearing. There are courts around the country where judges have 90% asylum approval rates. There are courts where judges deny 98% plus of asylum cases, which common sense would tell you that more than 2% of asylum cases are credible. Obviously, the law is designed, when Congress enacted asylum law, the law was designed in consideration of mass atrocities, genocides, holocausts, harm to life, harm to bodily freedom and integrity. So clearly there are oppressed people who are making these really arduous journeys to the United States. Just common sense alone tells you that when judges are denying 98 and 99% of cases, there's a really big systemic problem there. So I do want to talk about two cases that I did that illustrate this systemic problem and a little bit of the randomness of the immigration system and the adjudicators of the immigration system. So case one is a client who was born in El Salvador who had a severe cognitive impairment. He was abandoned by his mother as an infant and grew up in extreme poverty with his grandparents. He fled to the United States, but was kidnapped and abused on his way here. And he was detained, and he himself ended up being accused of gang membership. And the evidence against him was that there were Facebook photos of him wearing Nike shoes. Case two, a client born in El Salvador who was whipped and beaten by his father. The client's brother was murdered by a gang. The client fled to the United States and nearly died while he was traveling across the border. The client was accused of gang membership because he was seen near other gang members, and he was also near a fight that occurred at his school and was arrested on that occasion. And just to clarify, that charge was dismissed. And in terms of proximity to gang members, it's worth noting that his proximity to gang members was when he was attacked by a gang member and called 911 to report the crime and then cooperated with the investigation. Common to both cases, attending school, good work history, good family ties to the United States. However, both were abused, abandoned, neglected by their parents, which meant that they were both already eligible for a protective status called immigrant juvenile status. So these kids were on their way to becoming permanent residents of the United States right at the time that they were detained by immigration and held for trial for deportation. They were both accused of gang membership despite minimal evidence. They were both alleged to be verified MS-13 gang members, and I represented both of these people. Client one was deported after a federal appeal, habeas petition, and a rehearing on his asylum case. Client two was granted a green card after trial. So why do these two cases come out differently? Part of it is the randomness and the injustice of an immigration system where the Attorney General is in charge of the immigration judges. So it's not an independent court like other courts and other federal courts. The immigration court has this huge conflict of interest where the Attorney General can insert himself into cases, can remove judges from particular cases, can issue decisions that just become law without any kind of oversight. So that's the systemic issue. Part of the problem is the mental health care or lack thereof, which I'll get into in a little bit, which can have a huge impact on how well a client is able to participate in their own case. Clients have to testify and then be cross-examined by a Department of Homeland Security attorney. if their mental health is not in a good place, then their chance of succeeding at trial is significantly decreased. Part of the issue is the backlog in the federal courts. To the extent that you want to appeal these cases to an independent federal judge, oftentimes those solutions are impracticable because the backlogs are so significant that the client is already ordered deported, in some instances removed, by the time a federal judge becomes available to hear the case. And then obviously the effect of detention on the well-being of the client and the ability of nonprofits, social workers, school counselors, and others to provide support for this person. And we'll get into why so many of your roles are essential in these representations. I do want to highlight the inadequacy of the health and psychological care in these detention facilities. This is an affidavit from a federal habeas petition we did, where the psychologist said, in reviewing the medical records from the detention facility, the care that client receives with respect to depression is below the usual standard of care. Client has not been provided with adequate psychotherapy and has not been provided with medication, despite his having symptoms that could be alleviated with standard antidepressive medication and sleep medication. I would recommend weekly psychotherapy with an eye towards sleep and antidepressive medication. That client was detained for 7 months on spurious gang allegations, never received the recommended psychotherapy, never received the antidepressive medication, really received essentially no counseling whatsoever. And we had a petition pending with the federal court. So it's not as if we were not exhausting our legal remedies, it's that the legal remedies are inadequate and these detention facilities are so horribly run and so horribly funded. And the detention is so pervasive and prevalent with really a minimal use of discretion that we have people experiencing unnecessary additional trauma, unnecessary additional harm by the US government after fleeing here for protection. And I think it's really worth noting, although a lot of you probably know this, that these people who are fleeing asylum have never committed a crime. This is a civil context. So they are in a detention facility. Oftentimes, the detention facility is within a jail, or Suffolk County House of Correction, Plymouth House of Correction, but they're only held on a civil violation. So part of the problem with that, too, is that without it being a criminal charge, the rights are much lesser. They have much lesser rights to due process. They don't have a right to an attorney. Many kids go in representing themselves. You can look at articles of kids as young as 2 and 3 years old representing themselves before immigration judges. There's no right to counsel, and many, many constitutional protections will not apply to these cases, which is hugely problematic. And another problem is that, another systemic issue really, is that the information that's being used to prosecute and deport, especially young men, is unreliable. It's unauthenticated. This is the former Boston police gang detective commenting on the Boston Regional Intelligence Center. And this former gang detective said, I would never put this into a criminal intelligence database. The information that they're using to accuse kids of gang membership is wearing the color blue, wearing Nike shoes, flashing a peace sign while getting on the T in Boston, being near a gang member, but oftentimes those proximity pieces of evidence just relate to them being within hundreds of feet in the school cafeteria. Well, if the child goes to East Boston High School, and we know that East Boston High School does have a certain prevalence of gang membership, it would be an impossibility to expect that person to never come in proximity with a gang member. So the evidence is really unreliable, and it's really not relevant. But unfortunately, many adjudicators do take it very seriously, and many people have been wrongfully removed from the US when the sad irony is that they're trying to escape gang violence, not join a gang in the United States. And this issue of what's now being called the school to deportation pipeline has gained some traction. This particular article is a case that we did, and it says, it basically talks about how basic high school behavior, being in a cafeteria, getting in a schoolyard fight, will land somebody what is effectively the death penalty, which is deportation to a country that they fled because of an immediate threat to their life. This is another case we did where this intersection is so apparent between race and immigration. The headline says it all: gang database made up of mostly young Black and Latino men. And the over-policing of Black and brown communities does have deadly consequences in many ways. And one of them is that these kids are being put in gang databases and quickly deported. They're being detained. And in many instances, they're dying upon return, forced return to their country of origin. So this is a big issue that has in recent days actually caught traction, particularly with the Black Lives Matter movement. This is from Boston. Counselors are looking to defund programs for policing programs, and they're specifically looking at these programs around immigration issues. Is everybody? I'm gonna make sure everybody's with me. Okay, I still see everybody's here. I'm just double checking to make sure. Okay.
You're doing great, Alex. Mostly everybody in the chat is just, commenting on the content you have and how shocked or not shocked we are by the clear injustices of this system.
Okay, great. All right, well, I'm going to keep going. And if anybody, Amy, you can feel free to jump in if any questions, okay?
Thanks.
All right, so another big problem, we're still talking about these cases that are coming out so differently. And why are they coming out differently? And this is a bit of the conflict that I alluded to before, where attorney generals are inserting themselves in cases and they're basically running the deportation, what I would call the deportation system. It's EOIR, which is the deportation side of Homeland Security. So to our left, we have Jeff Sessions. To our right, we have Bill Barr. So Jeff Sessions issued a decision without any kind of review or oversight that basically said, it was called Matter of AB, and it said, if you're somebody who experienced domestic violence in your country of origin, if you're somebody who's been attacked by gang members or targeted by gang members, if you're somebody who's had your neighborhood burned down to the ground and you fled because of where you live, maybe because you're an indigenous person, well, if it wasn't the government itself who did that to you, then generally speaking, we're not accepting your claim for asylum, which that interpretation is in conflict with the asylum statute for a number of reasons. But what's really dangerous about that is that that instruction gave open access to immigration judges who wanted to deny asylum cases to do so. And many judges were denying asylum cases without even holding hearings. They would just say, following Matter of AB, which was Attorney General Sessions' opinion, it's virtually impossible to obtain asylum. And just a huge number of denials immediately came forth. That decision has been dialed back a bit by the federal courts and some appeals that have taken place. But unfortunately, we're still seeing in certain parts of the country where those federal orders have not taken effect, the Matter of AB is really preventing a lot of meritorious claims, and it's really preventing a lot of people who have suffered domestic violence, gang violence, gender-based violence, violence based on tribal heritage. All of those types of cases oftentimes are being denied because of that decision. And then we have to our right, Attorney General Bill Barr, who had issued another decision, which was called LEA 2. And in LEA 2, what he said is, if you are being harmed as a family member of somebody who has been persecuted, so for example, you're the family member of a political activist, you're the family member of somebody who is being targeted because of their race. One example is in certain countries, interracial relationships, for example. That generally speaking, your status as a family member of that person does not mean that you qualify for asylum, and those cases should be readily denied. That can become a huge problem for many, many cases, and has again been used to deny cases without due process, And I think I mentioned earlier, the first case story that I told about the family with the daughter who had severe physical disabilities, many people would hear that case and say, well, clearly they're going to get asylum. In reality, because of this decision of the Attorney General Barr, which came out several weeks before we tried that case was really questionable, because to say that the parents of this girl with disabilities should merit asylum really conflicts with the decision by Attorney General Barr. We actually had to argue that his decision was not valid, and we were able to get around it for a number of different reasons. But unfortunately, many, if not most, people in that position where they are family members of somebody who has a serious risk of persecution are forced to make the decision, do I leave my child in the United States, or do I bring them back to the country of origin where they're at risk of serious harm or death? The Refugee Protection Act would remedy a lot of these issues. It is an act that has been pending in Congress since about 2016. And I have put the information here to contact, if you're in Worcester anyway, your elected officials. Please screenshot this and do so. The act has come back up in 2019. This would remedy and reaffirm a lot of the asylum protections. It would say explicitly that domestic violence can be a ground for asylum. It would say explicitly that if you've survived human trafficking, you should not be afraid to go ahead and submit your application to remain in the United States. Similarly, if you've experienced crimes in the United States, you should not be afraid to come forward. So part of the problem that we have, though, with changing enforcement priorities and a lack of discretion is that so many sites, and so many of the sites that we work in, are no longer safe under the Trump administration. Schools, churches, and hospitals are no longer sanctuary spaces. That means that immigration officials can go in and they can enforce removal from the United States. There's been an assault on sanctuary policies in many states and many municipalities. We're also seeing the winding down of DACA, which is right now pending before the Supreme Court, whether the Trump administration has the authority to do that. But it puts about 800,000 extremely successful people who were brought to the United States as children. It puts them in peril. And then we see the administration's attempts to terminate temporary protected status, which is a protection for those who fled civil war or natural disasters. And again, the intersection of race and immigration is seen here in the temporary protected status wind down. Federal courts have actually said that the Trump administration's comments may indicate racial animus, and that this program, or the ending of this program, is being checked out for racial bias, and that there may be no legitimate purpose to end these programs. So that's, again, a huge intersection. The role of nonprofit agencies and health providers and community leaders is a huge role to fill. It's a necessary role, though, because, again, with all the cases that we've talked about today, part of why those cases were won or lost really depends upon the well-being of the client and their ability to participate in their case. So nonprofits obviously are providing wraparound services, but they can also bolster claims. If you are somebody who has credibility and you're a leader in the community and you can lend your credibility to an undocumented person fighting for asylum, that's a huge gift, because many of them rely on that kind of credibility that's lent to them. They don't have the social capital to go in and testify on their own behalf. They need somebody who can serve as a witness and advocate for them. Nonprofit leaders can advocate for policy changes, and nonprofits can also protect their own constituents from unlawful ICE and policing tactics. And then they can also help with legal, medical, and social services access. All right.
Alex, Rose did have a question. Rose is from ACE, and she was just going to unmute herself.
Okay, great.
And ask it.
Great.
Alex, I had a question earlier about you were mentioning the inconsistencies with response to cases. Is it possible, I'm not saying like this is how it should be, but I'm just curious because I don't fully know the process. Do judges ever make decisions on immigration case based on a quota? I've heard different discussions about the US having some kind of quota, and I'm wondering if that applies in some of these cases.
Absolutely. That's a great question, Rose. So the backlogs are a huge problem that immigration judges are facing, and particularly under the Trump administration. They're trying to create what they're calling a deportation force. And they've put quotas on immigration judges where a judge has to make, I think it's around 400 decisions per year. They have to dispose of 400 cases a year. The fastest way to dispose of an asylum claim is to just dismiss the case and remove the person from the United States. So many judges have just taken a cursory review of the client's initial filing, haven't taken testimony, haven't had an opportunity for cross-examination of witnesses, and they have just ordered the person removed. So that's a really good point, Rose, that the system, the quota system, has become a really big mechanism that forces unjust deportations without access to due process. And then, Rose, it's worth mentioning too, and I don't have updated info on this yet, but within the past couple of days, there has been what is called a proposed document on the asylum ban. It's about 160 pages of proposed regulations that would effectively bar people who are coming through Mexico from pleading asylum. It seems like it's extremely targeted towards immigrants from El Salvador and Guatemala. It's probably not legal. It's probably not lawful. It's probably going to be appealed to the federal courts. It's probably going to be blocked by an injunction. But the problem is that each time that the Trump administration does put these types of rules into play, is that there's a certain class of people who are deported during that interim period, and there's a certain class of people who are then afraid to plead asylum, and that chilling effect can just really increase the number of undocumented people who are continuing to be traumatized in the U.S. with their inability to work and their inability to participate fully in society. So absolutely, the quotas create a due process issue, but that's really in line, unfortunately, with so many of the policies of this administration have been a gutting of due process. Absolutely. I do want to talk about a few forms of relief that are available to undocumented people, and I'm only going to tell you enough so that you understand these for when you're working with this population. But asylum is a path to citizenship. It's for those who have suffered past persecution or fear of persecution or harm in the future. They have to prove that the fear is objectively reasonable, and credibility is essential in these cases. If a judge just says, I don't believe them, or I find that they're not credible, or they mixed up their dates, or they couldn't remember something that happened 15 years ago, which clients are often called upon to do during their trial while they're being cross-examined by a Homeland Security trial attorney. If the judge finds they're not credible, the case will likely be declined or denied, which means they'll be removed. So where do you all come in is in credibility. If you can write letters and you get to know your constituents and you can say, yes, on this day they told me about XYZ that happened to them. I found them to be truthful. I think they're a good member of society. I think that they will continue to avoid any problems with criminal activity. They've never presented anything that makes me question they're a gang member. In fact, I can account for where they are from 9 a.m. to 5 p.m. every weekday. Those types of letters can really lend themselves to a successful asylum case. So the more you know your constituents and the more you know about their immigration history, it's really all of our responsibility to step up and assist. This one's really important. Those of you who work with youth, special immigrant juvenile status is a really great immigration benefit that's often misunderstood and it's underutilized. This is for kids who are under 21, have been neglected, abused, or abandoned by one or both of their parents and cannot reunify. They're dependent upon the court to make this decision, which is just a technical element. They're unmarried, and it's in their best interest to remain in the United States. A lot of times people will shy away from filing these cases because they say, well, I'm not sure if they were really abused, or I'm not sure if they were really neglected. The fact that these kids were allowed to travel 1,500 miles unaccompanied to the border in and of itself is neglect. And that's not to put any blame on their parents. But most kids who are here who don't live with both of their parents are going to qualify for this program. As far as neglect, did you always have enough food to eat? Did you have electricity in your house? Could your parents protect you from the gang members? Did you ever get threatened by a gang member? You will find that most kids will qualify. And under 21 is hugely important because so often kids come in and they're 22 or 23. They would have qualified and they never knew about this program. And another aspect of this is that a lot of people tend to just associate this program with Central American applicants, but people from all over the world can qualify under this program. So definitely keep this in mind with whatever constituents you're working with. And if you're in doubt, connect them with legal services, which we'll talk about. Good moral character and discretion is the foundation for so many positive rulings. Basically, because the immigration system can be so random, you want the judge to like your client, and you want your judge to feel like they deserve a shot at remaining in the United States. So again, their ties to your organization, their community ties can be really determinative of whether or not their case will be approved. So again, that underscores the importance of building strong relationships with your constituents, getting to know them on a personal level, and then stepping up to support them in their immigration process. And many of you work in contexts where you have the opportunity to provide rehabilitative services, and you can speak to people who have made mistakes. Maybe they have criminal history, maybe they have addiction issues, maybe there's some other derogatory information on their record. If you can contextualize that and you can say, I know that this person has or had an addiction issue, but they have done A, B, and C to remedy that, and I believe that they will remain a productive member of society, that letter is going to have huge weight. I've seen that on a number of naturalization cases where officers decided that the person did merit the benefit despite derogatory history. I do want to mention, this is in the context of COVID-19, public benefits and public charge. This is another deterrent of the Trump administration. This is for people who are seeking family unity, people who are applying for a spouse or a child or a relative to come into the United States. As of February 24th, 2020, there are significant financial limitations on who can enter the United States as a permanent resident and who cannot. And the big fear that a lot of people have is, well, if I take this public benefit that I really need right now, I'll never be able to apply to bring my child here, or I'll never be able to get a green card. And the truth is that it's a balancing test. There's no blanket answer to say, no, don't worry about it, take that benefit, because they have to balance the fact that they need this benefit to survive, but then the immigration risks. And I think it's really an individual analysis for each person on whether or not the rule will apply to them, and whether or not the risk is worth taking, and whether or not they simply need the benefit and have no choice. But we don't totally know yet how this rule will be enforced. And it does primarily affect people who are applying for green cards, but it could be used or utilized to try to deport people from the United States as well. I haven't seen that yet, but it's a really serious risk that needs to be taken into account when making that decision. And I would not advise anybody working in an agency to do that analysis without the help of an attorney. Community Legal Aid has some real experts on public benefits issues, so I would definitely defer to them as well. Something, though, that this is a little bit of a positive: unemployment is an earned benefit. It's not a public benefit for immigration purposes. So keep in mind that non-citizen workers who are authorized to work and have accrued unemployment insurance benefits can access those during the coronavirus. And there's information, there's a link in this slide, which I know that the slides will be available later. Emergency care and COVID-19 testing. USCIS actually published guidance on this because they wanted to clarify that everyone with symptoms resembling COVID-19 should seek necessary medical care. If somebody gets a COVID-19 test or gets medical treatment that is covered by Medicare or Medicaid, that will not prevent them from becoming a green card holder on account of public charge issues. Same thing goes for Mass Health Limited and Mass Health Safety Net. So if somebody is getting emergency medical care only, they're not just doing elective things, that will not harm them with respect to getting a green card. And keep in mind that a lot of times people live in mixed status households. You have children who are US citizens and parents who are undocumented, vice versa, and all different combinations. So keep in mind that some people in the household may be citizens and may be eligible for certain benefits. They should access those benefits if they need them. So there are more detailed resources and guides that are linked here, definitely worth checking. But again, a lot of these analyses are fact specific, and I'd be happy to help somebody in a specific case. Federal stimulus payments, this is a huge area of concern, whether those $1,200 checks can be accessed by undocumented people. They're available to permanent residents who file taxes. But we need to call our legislators and change that undocumented people or those with tax ID numbers are not eligible for the checks, and people who are married to undocumented people and undocumented workers are also not going to be eligible for the checks, which is really probably a due process violation. Funds are available, though, at least in the Worcester area in Massachusetts. Please just definitely check out or help your clients check out the Mass Undocu Fund. People can apply on a rolling basis to get funds as they become available. And again, we need to think about Worcester-specific funding. There is funding available through Catholic Charities, Friendly House, and Ascentria, where a client can go in and tell their household size, their country of origin, and their zip code. And if they're undocumented, they will be provided a $500 gift card, a Visa card, which is just cash assistance that has no, it's from a private donor and it has no implications for their immigration status. So that's a great resource. So again, it's Catholic Charities, Ascentria, and Friendly House who are in charge of that. So I do want to think about, I do want everybody to just think about, these are some questions I'll raise, and before we go into a question and answer, what is your plan as an agency from your policy perspective? Are you applying for funds specifically to help your undocumented constituents and fulfill their special needs, specific needs for wraparound services? If you're not, this could be a really big grant opportunity for you, because certain foundations are really focusing on the undocumented population right now. So certainly if you are thinking about setting up a fund for your undocumented constituents, that may be wise to do. What mental health care and counseling are you providing? What partnerships can you make? How can your cultural organization incorporate mental health care and support it into its programming? I find that so important, because we have to remember mental health care is not just about sitting in a room with a therapist. It's not only about that. It's about cultural connections, cultural programming, and just community connection and people's affinity to their own culture. And that can be hugely beneficial. So I know some organizations already do that very well. What is your policy around emergency mental health services? Obviously very critical, especially as coronavirus disproportionately affects immigrant and undocumented populations. How are you ensuring that undocumented populations are receiving physical health care they need? What are you doing to help your clients as they assert their rights in the workplace, in courtrooms, in schools, in their homes, and in working with the local police? We have to remember that many, many people are from rural areas, and then they come to the US. They've never been in an office building before. They've never been in a school before. They've never been in a courthouse before. So that can be an incredibly intimidating process. And many of them have such distrust in the police. That's something that certainly an agency could put a plan together to guide people through those institutions. Do your constituents know what to do if ICE shows up at their home, at their school, if a family member is detained? You know, so many of our agencies are working on the well-being of kids and the well-being of families. I mean, it's part of our responsibility to make sure that if there's an undocumented family member, that we do what we can to educate them about their rights, so that the well-being of their family is somewhat protected, even despite all the horrible enforcement practices that are done right now by this administration. Do you have a plan if ICE shows up looking to make an arrest at your agency? I know that the Worcester Public Schools has a plan. I'm not privy to exactly what the plan is, but certainly there should be some high-level supervisors who would meet ICE officials to ensure that due process is followed, that a warrant is present, and that the child is protected, or the person being sought is protected to the biggest extent we can. Granted, you have to walk a line because you don't want to be obstructing a prosecution. So that's something that really has to be looked at closely, and there are some resources in the next slides about that, and I'd be happy to talk with people about that offline. Do you have a bail fund or an emergency fund to help immigrants with urgent needs, legal or otherwise? There are situations, for example, with DACA, where $500 in filing fees will be the difference between whether somebody is documented or undocumented going forward, or whether somebody can work or not work going forward. Those type of funds can be really critical to preserving the well-being of your constituents. I would encourage everybody to think about that, especially where people's financial situations have been destabilized so much by coronavirus. I think it's absolutely essential. Have you educated your staff on possible immigration relief to look into, and then also advise them about the risks and illegality of providing legal advice if you're not licensed? So again, having people have an awareness around immigration issues and knowing when to ask for help, but having that humility to say, I need an expert on this, is really important, because You want to encourage people who are eligible for benefits to get them, but you don't want to put them at risk by applying for something if they're ineligible. And then I have here some resources as we kind of start to wrap up. These are resources that talk about how families should respond if ICE shows up at their home, guides to public benefits, specifics on public benefits. And then the CGRS at UC Hastings is a great resource for psych experts and all kinds of information about trauma that I use all the time in representations. I think it would be really helpful for people to just browse. And I do want to mention too, I don't know if anybody's on here from UMass, so you can jump on too, but the UMass Medical School does now have an asylum clinic where experts are available to provide forensic evaluations for people who have survived persecution or torture in their country of origin, and who really would rely on that type of medical care either to get referrals to further long-term care, but in my instance, would rely on that evaluation to corroborate the trauma they experienced in their home country. So there's contact information here. So again, I encourage people to screenshot the information. But that's a really huge resource. This is something that's always much needed and is excellent. My information is here. You can reach out to me. If you contact me on my direct line, just text me. I'd prefer that, but you can contact me at the office or my direct number. And then the Community Legal Aid does have an immigration department, which is excellent. The Edward Kennedy Center, Family Health Center, and Community Health Link are all federally funded and are required to treat and serve people regardless of immigration status. So those can also be great resources. And that is what I have prepared, but I'm really happy to take questions and talk a little bit and hear from you all.
That was so amazing, Alex. So much great information. Lots of people had things to say. Many of the people in our audience are working with immigrants and at agent, we've got people from ACE and Ascentria. I know Bill Gardner had wanted to ask some clarifying questions about what you'd said earlier. So Bill, if you want to just turn, there you go. He's unmuted.
Alex, that was really some great information. Can I get you a water or some oxygen? Because you really, well, you laid it out there, man. So did I hear you correctly? This is, as an example, being a victim of domestic violence is one of the reasons that one can apply for asylum to begin with. But the Attorney General denied that and other reasons because the abuser, in this case, wasn't the government. Right. That doesn't even make any sense.
No, it doesn't. And it's the argument that you can make to get around that. Well, first of all, the First Circuit Court of Appeals has kind of pushed back on that. But their argument is always, well, you're opening the floodgates. So many immigrants are going to come here. So many people are going to come just saying that they were abused. They're going to make up claims. What that misunderstands, though, is a couple of things. First of all, most people are not coming here and enduring an extremely traumatic and extremely dangerous journey to the United States to make a false claim or to seek protection that they don't necessarily need. This is a decision that people make after giving it significant weight, after hearing about the many people who have died on the way here, people who have been attacked, raped, murdered on the way here. So that's the first misunderstanding of the decision. Second of all, though, is the idea that you can deter somebody from coming to the United States by issuing a decision like this. Because the bottom line is that nobody in El Salvador, Honduras, Nicaragua right now is reading the Attorney General's decision saying, I was going to go to the U.S., but now I'm not because asylum is more difficult. When people are fleeing for their life, they can't be deterred. So third, I don't think it's even a reasonable objective to try to deter people because I don't see what the downside or the risk is. But even if you did agree with the premise that people should be deterred or that people should be limited when they're trying to apply for asylum, then the decision doesn't really do that. What the decision does do, though, is that when people have actually sought protection in the United States, it does put them in a position where they're highly likely to be removed from the United States and further harmed. What it also does, though, is it puts them in a position where they have to have a fear of applying for asylum. So now they're physically present in the United States, but they're unwilling or unable to come forth and obtain benefits, start working lawfully, start engaging with the economy, engage with the policing forces, help with our national security. So it gives people in reality a disincentive to participate in American life because they're afraid to do so. So it's a really, the decision is based on a really, I think, inhumane premise, and I don't even think it's effective. I think it hurts every element, economic, social, national security. So you're absolutely right, Bill. It's just a horrible decision.
And how does the checks and balances that we all learned about when we were in school, you know, the legislative, executive, judicial branch, when all those things are supposed to counter each other, how is the AG able to make sweeping decisions like this on his own or on their own when those checks and balances are supposed to be in place?
I think you're right. I don't think that the AG really had the authority, and that's a really technical argument. I know people are making it, but that's working its way through the appeals courts now. And the problem is that this decision will probably be in effect for a couple of years before anything changes. So because of the pace at which the checks and balances occur, so much damage can be done in the interim. The Refugee Protection Act of 2019 that I mentioned would remedy this decision. Good luck getting Congress to pass it. It's been on the table since 2016. So that's the problem, is that I think we have this abstract idea that government works a certain way, but unfortunately, practical problems get in the way. I will say, though, Bill, interesting that you bring that up about checks and balances. Here in Massachusetts, we did have a good example of things with checks and balances working correctly. The federal government on immigrant juvenile cases was saying, no, we think the kids should be under 18 if they're going to be considered a juvenile. Massachusetts courts said, no, they're under 21, they're under our jurisdiction as far as the probate court is concerned. The state legislature actually ended up passing a law to affirm what our court said, and we ended up getting a piece of legislation passed that said, no, up until 21, the federal agency has to continue to process these cases as immigrant juveniles. The federal agency tried to prevent it, and appeals went up, and they were forced to admit these kids as immigrant juveniles. So there are examples of where the system works, but unfortunately, it's not in every case, and unfortunately, it takes too long for many individuals who get hurt in the process.
Awesome. Thank you very much, my friend.
Yeah.
Alex, can I just quickly piggyback on Bill's first question, where it relates to domestic violence and the law that the AG passed, saying that the abuser is not the government. So the AG is saying that you cannot seek asylum on that ground. With the knowledge I have, the abuser you have to prove that the abuser is the government, or the government is unable to protect you from in my country, Jamaica, a domestic violence situation, the cops will come if you call them, and they'll say, oh, it's a family matter. That's a typical example of the government is unwilling to protect that person. Now, is the AG's laws valid here?
So that problem you point to is really exactly right. And what we do on my cases is we say the AG's rule is in complete contradiction to the asylum statute. Because as you said, the asylum statute says the person is unwilling or unable to avail themselves of the government's protection. So if the police force is just totally incompetent, or worse yet, if the police force is malicious and the person cannot avail themselves of protection, then they should be able to get asylum. So the Attorney General's decision is in conflict with the asylum statute. It's also been invalidated by a number of the federal courts. But the practical problem that we're seeing is that because the judges work for the Attorney General, they are more inclined to follow the Attorney General's order in some instances than to follow federal law or to interpret for themselves the asylum statute and say, I don't think the Attorney General's rule was valid. And that is part of why so many cases are decided disparately. In Boston, many of the judges are saying, yeah, the Attorney General's decision in AB does not apply here, or it doesn't stand for the fact that all these cases are foreclosed. But there's huge swaths of the country where judges are saying the complete opposite. So you and I can agree that the AG's decision is completely wrong, but that doesn't stop these bad interpretations from occurring. And it does give people a certain level of authority and legitimacy if they are going to just outright deny cases without due process. And that basically their boss is saying, go ahead and do it.
So that's something you as a immigration attorney would argue in immigration court, correct?
Oh yeah, of course, yeah. So definitely what we would argue is, first of all, that the Attorney General's decision is invalid. Second of all, that even if it were valid, it does not apply to this specific case because this person either tried to contact the police or were unable to. Third, we would say, well, the conditions of the country demonstrate that the police are unable or unwilling to protect this person. So you would argue all those things and see which one the judge agrees with.
All right, thank you.
Yeah, absolutely.
All right. Hi, everyone. So my question is on the public charge. You went through that, and could you kindly clarify or verify, like, what would be probably, as far as it's not very clear right now, but what would be your pointers, like maybe as a red flag, for example, like what someone should totally avoid? Because I'm thinking like when I at the point of entry, you're not given the green card, but you get a stamp as you wait for your green card. But more often than not, if you have children, I've heard of many cases where the children get their green cards even before you, who's your guard, like in my case, my children got their green cards before I did. So you operate with a stamp, and unfortunately, it's like the systems have a disconnect when it comes to USCIS and local administration. And that I mean like Social Security offices, where you might go in with a stamp, they don't give you a Social Security card, and then there's a back and forth for clarification with USCIS. Then by the time you're getting your Social Security card, it's a delayed process. I mean, really shouldn't have been there. So when that time lapses, there's certain pointers. It means you won't be able to work immediately because you don't have a Social Security card. You can't even open a bank account without a Social Security card or the green card, which you haven't received yet. So it's like a vicious cycle. And now when you sit back as you wait for your documents so that you can work and feed your children, then you're forced to get food stamps because that's the only way your children will be able to eat. So in that prospect, kindly just give me a few pointers or what insight on the public charge.
Yeah, that's a really good question. It's a huge problem, and what you're pointing to is there's a huge disconnect between, first of all, USCIS's requirements and how practical life works. For example, if you're trying to prove a family relationship, they want to see that you have a bank account together. Meanwhile, your bank might not let you open a bank account until you have your green card. They want to see that you can support yourself financially, and they want to see that you're not going to be relying on public benefits, but they don't issue you a work authorization until 6 months after you enter the United States, and the Commonwealth of Massachusetts doesn't let you get a driver's license. So there's a huge disconnect between state agencies and USCIS. The USCIS regulations themselves often don't fit the requirements that they're trying to make people practically provide to them. But as far as the public charge is concerned, I'd be really reticent to say specifically, okay, these you can accept and these you can't, because first of all, public charge will not apply to certain classes of immigrants. And you got to first figure out whether or not public charge applies to you. Generally speaking, if it's a family-based case where you have a spouse or a parent or a child petitioning for you, public charge will apply to you. But you got to remember that certain humanitarian cases, like people getting green cards based on asylum, survivors of crime, survivors of human trafficking, survivors of certain other, or I should say certain other types of humanitarian benefits will not even consider whether you've accepted public benefits or not. So first, you got to figure out, does this rule even apply to me? And that's a really technical consideration, but generally speaking, it's going to apply to family-based immigration. And then second of all, you got to figure out, okay, is this benefit a public benefit for public charge purposes? Generally, emergency health care is fine to accept. Mass health would be fine to accept if it's for emergency care only. So I think they call it safety net, would be fine to accept. But food stamps, if you're eligible and the state finds you eligible, generally speaking, it's okay to accept, although it could be used as a factor in determining whether or not you'll be self-sufficient. So again, that's kind of a technical question, and you've got to do that on an individual basis. If the food stamps are for children, if it's WIC, generally speaking, that would be more acceptable to the immigration agency. But again, all of these questions should be considered individually. In many cases, housing is acceptable to the immigration agency. If you need Section 8 assistance, that's okay. But again, you're dealing with officers and adjudicators who have a lot of discretion, and you can't guarantee how a certain person is going to interpret the rule or if they're going to interpret it correctly. That's why it's always a balancing test. Do I want to take this benefit and take a chance or not? So I would encourage you definitely to take a look at some of the guides that are linked in the presentation. They're pretty clear, but again, if somebody had a specific question, I think you would really want an attorney to look at it each time, because this is constantly evolving, and it really would depend on the basis of the person's case and also the adjudicator, and also how the public charge rule develops over time.
All right. And sorry, quick question also. For the kids, for the children, so long as they're minors, is it from your basic knowledge, if they're here on a green card and they're under 18, like 8, 5, 3, like really young, is it true that they could be eligible for citizenship if whoever sponsored them is a grandparent who is
well, that would depend. So you're talking about like whether they could automatically become a citizen?
Yes.
Applying for it. So usually the automatic acquisition of citizenship comes from a parent, not a grandparent. But it could depend on whether or not the grandparent has custody or guardianship over them. So that again would be kind of a fact-specific question. But generally speaking, it's automatic through a parent. As far as a grandparent's concerned, there are scenarios where it could be automatic, so we'd have to take a look at the specifics.
All right. And probably I should end it there, but talk to you on a different platform. Thank you.
Sure. Okay, thank you.
All right.
I think Christine was next if she wants to unmute.
I will do so. Thank you. Hi, everybody. So I've mostly been working as an addiction counselor over the last few years. So I've had enough experience with the DSM, and I know how stigmatizing that is, even for people who are not immigrants. So my thoughts were, my question is, what are your thoughts on clients being diagnosed with a disorder rather than being viewed as a person who is rightfully experiencing distress due to what they've experienced? And can the DSM of mental disorders be used to further subjugate immigrants and keep them from exercising their autonomy?
Yeah. So basically, the problem that I think you're pointing to, which is something I've dealt with on a number of cases, is the immigration law has not caught up with healthcare's treatment of addiction. So obviously, addiction being considered a disease would imply that the immigration agency should be more forgiving or more understanding if somebody is trying to be admitted to the United States despite their addiction. Unfortunately, there are these really, really antiquated bars to admission to the U.S. as a green card holder. One of them relates to what's called habitual drunkard, which would be somebody who's had issues with alcohol. It's really comes down to what they're considering as a moral consideration. They're not so much thinking about it in medical terms. They think of it as a really antiquated moral analysis. And then the other issue with addiction issues is that oftentimes, if somebody has addiction issues, they may be able to get by and saying, okay, I've gone through treatment and I'm admissible to the US, but then they'll get hit with another, and I've had this happen, a really nebulous charge saying, well, we have reason to believe this person was a drug trafficker because they've had multiple charges relating to drugs. Obviously, there are ways to argue against that, but it's a significant risk. Definitely the immigration agency has not caught up with addiction services and our understanding of it. But there are arguments that you can make, particularly if somebody has a long history of treatment and has complied. Like if somebody has probation and they were, or had probation, and then they went through a program and they complied with the terms, you can certainly argue that this person is no longer, at least from the perspective of immigration, I wouldn't use these terms, but no longer like a risk to public safety and so forth. And then you can also argue that they still maintain good moral character because of other positive factors. So basically, in some cases, the agency will consider this as one factor on the analysis, the discretionary analysis of whether or not this person has good moral character. So in that discretionary analysis, you want to bring in other things like their work history or their family ties or their community involvement to kind of counter that, what immigration is going to consider a derogatory factor. I hope that answers your question, but it's really, again, it's a case-by-case analysis of whether or not the person is likely to face a charge of inadmissibility and whether or not that would likely be overcome. You do want to be extremely careful with it, though, because in certain instances, somebody who's a green card holder, for example, who does have a history of addiction, not only could they be denied citizenship, but then they could be referred to the immigration court for possible removal. I've seen that happen when people have unwittingly applied for citizenship, not thinking it would present an issue. The consequences can be really, really harsh. So definitely a great question.
Maria, Emily?
Oh no. I kind of had a follow-up question. It's Christine again. I don't know if that is okay to ask.
Sure, go ahead, Christine.
Thank you, Amy. So great stuff. Very eye-opening about the stigma of addiction. But the other element to my question, there's kind of a little anecdote. So I used to work at a group home, and there was a lady who had escaped like horrific, like she just came from a horrific war-torn area. And what she would do was hide in her closet, and just because she thought people were coming to hurt her again. And I think her diagnosis was something like schizophrenia, or like one of the really highly stigmatizing ones, when really she had legitimate fears. So I'm wondering if even in diagnosing people with more like psychotic sorts of situations, if we're totally missing the mark on what they're experiencing.
So if you could just clarify the question, I'm not sure if you could just kind of clarify or synthesize the question.
I guess would you find like are people like disproportionately diagnosed as an immigrant with more psychotic disorders that you're aware of, or just different religious practices that get really targeted as like a psychotic thing and not a cultural thing?
Right. Yeah, I mean, I don't have a great handle on it because I don't think I have enough of a population that I could make a blanket statement. But what I will say is that part of what we deal with a lot is kind of that question, particularly in the court setting where you'll present a statement from somebody that says, okay, this client has PTSD or whatever it may be. And the prosecutor will say, well, isn't it true that 95% of the people you work with get diagnosed that? And for some of the experts, that is true because they specialize only in, former child soldiers from South Sudan, or they work only with, people who have experienced significant physical harm or significant loss. So that's a really big question, and definitely something that I think that all, mental health professionals have to think about is being judicious in when to diagnose and when not to. And there are a lot of guides about that, about cultural competence in working with asylum seekers, and also how to advocate for a client without inserting yourself into the case. Because frankly, an evaluation will become more harmful than helpful to the case if it becomes clear that the adjudicator is putting information in the expert statement that is trying to argue on behalf of the client. So for example, if the adjudicator puts in there like, I believe that this person merits asylum. Obviously, that's a really specific example, but you don't want to argue on behalf of the person. But even things like, I believe that this person is telling the truth. That's a decision that some judges might say, okay, well, the mental health professional built a good rapport and trusted this person. Some adjudicators might say, this mental health professional is trying to tell me whether or not I should believe this person, and credibility is my determination to make. So I would say that on a given case, you can work with the attorney, that if you are providing an expert statement or providing a diagnosis for purposes of immigration, definitely you want to know who your judge is, and you want to know what would be beneficial to the client. Because I think the temptation can be that everybody wants to be helpful, and you want to be really judicious in what you say and what you don't.
Hi, everybody. This is Mary Emily. I have a follow-up question regarding DV or domestic violence victims coming into court. Mainly, my question was, I get a lot of victims, and part of my job entails that I provide services and referrals and notification to our victims coming into court. But what is an advice or something to keep in mind when you have victims coming into court who are hesitant to speak to you or be involved in a case that's bringing them to court for fear of being deported?
Yeah, that's a really good question. I think that's a really tough barrier to break down, just because the distrust in policing and in judicial systems in so many countries is just so pervasive. But I think just reminding them that this is something that will be to their benefit, that they're generally speaking going to be protected. There's a whole class of visas that I really didn't have a chance to talk about that are called U visas for people who survive crimes here in the United States. And so if they choose to go forward with a prosecution, then generally speaking, the prosecutor will sign off and will say, this person assisted in the prosecution, therefore they merit protection because they cooperated with law enforcement. And it's a path to get a green card, and it's a path to citizenship. Essentially, participating in a prosecution as a survivor of domestic violence will only help your case. It certainly will not hurt your case, particularly in Massachusetts at this point. Some people might have fears about being arrested in the courthouses because of some rulings at the state level. That will not be happening, at least in the current moment. Especially if you're a witness and you're not being charged with a crime. Nobody's going to be effectively looking for them, trying to remove them while they're trying to access justice through a prosecution. Something to be aware of, though, is that U visa cases take a really long time to complete. I mean, we're talking 5, 6, 7 years. That's because of the backlog of the visas that are available for survivors of crime, at least at this time. But what I would remind people to assuage their fears is that if you start participating with the police and law enforcement, you don't have to continue. They can't force you to move forward with the case, and you don't have to get the person convicted or go to trial in order to benefit from a U visa either. So just, I think, reminding the client that they're in control. It's up to them what they want to do, how they want to approach it. But I would suggest too, at least from a legal perspective, that they should be not only participating in the prosecution, at least to some extent, or at least at the beginning, but also getting those wraparound services and working with counselors, right, mental health professionals to support them through that process. And also it's going to support their case ultimately.
That was very helpful. Thank you.
Sure.
Alex, just a follow-up on that question just now. I know that in a sense, they try to preach that if you should not be arrested while being in court. But I know they also press that if you're undocumented, it's better to stay out of court. And so going back to that question, wonder if this client was refraining from going to court because they know personally that they're undocumented. Yeah, because I know in immigration court, like you can have a witness that wants to testify, which is in the best interest of the respondent here, but they say don't come to court because you're undocumented and you risk being arrested by ICE. So going back to this client of the DV situation, who to tell if they're not undocumented? What would you say to them if they're undocumented?
Yeah, that's a great point. I want to be really clear about that we're talking about two different courts. So for the domestic violence cases, you're in state court, right? You're prosecuting in the Massachusetts state courts as a survivor of domestic violence. As that prosecution occurs, the Commonwealth of Massachusetts will certify that you participated. Then you go to the federal office and apply for your visa. So you can assure somebody that if they're in the Massachusetts court, although there's nothing in this world that's guaranteed, and what I tell people is you don't know that somebody in the Trump administration is going to follow the law, right? But you can at least make an educated move to know that the risk would be extremely low of an arrest if you are a survivor of domestic violence going into a state court to apply or to participate in the prosecution of a criminal. Not so with the federal court. With the federal court, I would not advise somebody who's undocumented to go to any federal building or any federal court or an airport or anywhere that immigration officials would be present. There's a big distinction there. You're absolutely right that for the immigration court, you do not want witnesses who are undocumented to be there. But for the state court, because of these recent rulings, the participation of the Suffolk DA, you can look into the articles about this, but the Suffolk District Attorney and the CPCS, the Public Defender's Office, came together. It was a very historic collaboration. And generally speaking, ICE officers are not going to be at courthouses or making arrests in Massachusetts, right? And that's at this time. That could always change. So that's a question you have to ask every time you're thinking about doing that.
Okay.
Can I go, Amy? This is Sugarman. Thank you so much, Alex. I just want to backtrack a little bit to the concept of trauma. What are some of the transnational or culturally bound perceptions of trauma that sometimes you think can go unidentified by our Western mental health system in the definitions of how we see trauma, that also sometimes affect juries, affects judges, and affects DAs and lawyers? That sometimes, for example, I work with indigenous migrants from Ecuador, for example, and many times one of the coping mechanisms, and I'm generalizing grossly right now, is to not show emotion. You know, and many times people are judged by that, just how we see our cultural way. What are some of the things that you've seen in asylum cases that sometimes the asylum is lost or it becomes really complex when the question of whether the person is undergoing trauma comes?
Yeah, that's a really good question. So this is something that we run into in kind of an ethical question too, because sometimes you see that clients are not participating in the expectations that we as Western people or we as or the adjudicators, which are primarily going to be, you know, white American born, usually older people, these adjudicators, and most of them with a military background, or many of them with a military background, not most, but many. So sometimes the question becomes, okay, do I encourage my client to play into the stereotype and expectation of the adjudicator? Different people have different interpretations of that, but what I remind clients is that they're advocate, they have to advocate for themselves too. And so you don't want the client to go in and be totally stoic, because again, that culturally that may be lauded, but from a credibility perspective, I think a judge would be confused by that. I can't speak to, every individual culture, but some of the things I've run into, a lot of times religion plays a really big factor. Clients feel compelled to say certain things or do certain things that I think would really cause a judge to question whether or not they're acting, even though they may be totally genuine. I've done religious persecution claims where clients have asked to say, prayers during their testimony and so forth to prove a point, or they've memorized certain passages of different scriptures and they're trying to prove, okay, I'm really of this religion. It's a tough question because you don't want to, you want to respect the client's autonomy, but you also know how an adjudicator might interpret that. So those are conversations you have to have throughout the representation with the client. You don't want to interfere too much because anything they do has to come off as authentic. Kind of related to that, sometimes clients or sometimes attorneys will encourage clients to review their statement and try to memorize certain passages of their statement. I would never do that because if they're just saying word for word what's been written into the filing, then an adjudicator is going to assume that they've memorized it. Whereas the client may really want to do that because they think that if they appear educated and present well, that that's going to help their case. A lot of the issues come down to, the level of educational background, cultural differences, rural versus urban. And a lot of it comes down to language. With indigenous populations, a lot of times the interpretation services are not adequate during the trial, which is something you can really push back on, and I think people should push back on. But even, I think one of the biggest variables that I see is just that people where poor living conditions or certain abuses have become so normalized that they don't feel it's worth mentioning. So, people who will just say, like, tell me a little bit about your childhood. Oh, it was fine. It was extremely normal. And then you get into it and it actually, there was significant domestic abuse and poverty and starvation and so forth. So I think that those obstacles have to be addressed early in the representation because otherwise you're not going to develop an argument. And we run into that all the time. Sometimes it'll be 2 or 3 meetings before you realize that there's even an asylum claim available to you or available to that person.
Thank you.
And I will say too, that that's part of the role of, I don't know if this is what somebody just said in the chat, so sorry if I'm repeating this, but hugely important cultural organizations and counseling services. Sometimes you learn things about the client that they never disclosed to you through a witness who had built that culturally competent connection with them. So that's really important.
I know Luz had a question and she was going to unmute herself and jump in, but there you go, Luz. Are you there? She's there. Go ahead, Luz, we can hear you. You look like you're unmuted. Luz, you got it? If she's having trouble, she did type her question into the chat, and it was around could divorce be grounds for deportation? Let me see, I don't have it exactly, but that was the sort of the gist of it.
Yeah. So what I always tell people is, don't do something.
Sorry, can I read it for you guys? I can see it.
Great.
Can a married couple, one of them being undocumented, get divorced without putting at risk for deportation the undocumented partner?
Thank you.
Yeah. So definitely in Massachusetts, somebody can access the state courts for a divorce without risking, in any significant way, without risking deportation. What that question might be asking, though, is if the undocumented person is relying on the U.S. citizen or permanent resident spouse in order to get status for themselves, obviously a divorce could interfere with their ability to become documented. However, I would never tell somebody to stay in an abusive relationship or to persist in a marriage that they don't want to be in just because of their immigration status. There may be waivers available, and there may be relief under the Violence Against Women Act, which protects both men and women who are in domestic abuse relationships, who are married. Basically, the immigration law does allow, in many instances, for people who are in a marriage that they don't want to be in to get out of it and still obtain immigration status. Not in all instances. If there's no abuse or there's no humanitarian factors, that person may not be able to become documented through the marriage after divorce. But certainly, I would never encourage somebody to just stay in a marriage for immigration purposes. It's not going to work out from a very practical perspective if they're trying to get a green card through marriage just for purposes of evading the immigration laws. It's not going to work out. That's going to be discovered by the agency. They have tremendous power to investigate. And if they're staying in it and it's to the detriment of their own physical safety or mental health or well-being, then obviously they need to get out of that situation. And in many instances, a waiver will be available or some mechanism to get status may be available.
Anyone else have questions that they wanted to ask Alex? I know a lot of people are really interested in getting your slide deck. I think that you had so much great information, and certainly you had lots of things that we can do as either human service professionals, just as citizens. It seemed like there were some definite advocacy points, and I love, you know, kind of learning that our statements can really, really be valuable for people.
Yeah, absolutely.
Well, then I guess if there's no more questions, just again, want to thank you so much. This has definitely really been so helpful. I learned a lot of things I didn't know, and I know to have your time and expertise freely given to us is really, really an incredible gift, and I'm so grateful for it. And I know other people share that sentiment. So thank you so
Absolutely.
much for being
Yeah.
here. We really appreciate it.
My pleasure. I'll put my contact info in the chat. I saw somebody had asked. It's on the slide too. I'm here. I always tell people, reach out to me. Questions, complaints, objections, anything you want to send me, I'm willing to read it, and I'd be happy to hear from you.
That's so great. Thank you so much, Alex. And then if you send me your slide deck, I can post some of the slides I'll post them on our Facebook page. If people don't already follow Worcester Addresses Childhood Trauma on Facebook, please do. And again, if you need an immigration attorney, you know who to call. He clearly has so much information and understanding of the system well beyond what I ever knew. And it seems like many of us learned a lot from you today, Alex. So
great.
We're just so grateful. Thank you so much. It's very appreciated.
You bet. Take care, everybody.
You too. Thanks, everybody. See you next time. Trauma of Sexism.